Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall. Today's episode is What Will Happen to Competition Law Enforcement in Mexico? Implications of the November 2024 reforms. My co-host today is Subrata Bhattacharjee. Hello Subrata, and who is our guest today?
Matthew, how are you? Nice to do this with you. And today we've got Lucia Ojeda Cárdenas with us from Mexico. She is a lawyer partner at SAI Law Economics based in Mexico City. Her principal areas of expertise are Mexican antitrust and competition law, regulated markets, arbitration, and trade remedies. Lucia, thanks for coming on the show and frankly telling us a little bit about what's a very important development.
Thank you very much for the invitation. I really appreciate it.
Lucia, also thanks for me for coming on. Just by way of brief introduction, following approval in the lower house on 28 November 2024, the upper house of the Mexican Congress approved a decree modifying the Mexican Constitution to eliminate various constitutional bodies. These included the Federal Economic Competition Commission, which is the Mexican merger control and competition law regulator for all sectors other than telecoms and broadcasting, known to most as COFECE by its Spanish acronym. Also covered was the Federal Telecommunications Institute, known as IFT by its Spanish acronym, which deals with regulating telecoms and broadcasting and also competition law enforcement in those sectors. I understand now, having gone through all of the steps, these organizations will be merged into a single competition regulatory body within the Ministry of Economics, with the non-antitrust powers of IFT being dealt with in a separate regulator. Needless to say, as Subrata mentioned, this is a pretty unusual development in the antitrust or competition law world, and has given rise to significant uncertainty. There seem to be impacts or potential impacts across all aspects of merger control and competition law enforcement in a jurisdiction where many listeners come across issues on a regular basis. So Lucia, could you just briefly tell us why and how Mexico got to this point where the regulator has been abolished and changed?
Yes, these agencies enjoy a set of institutional guarantees, to allow them to act independently without being functionally subordinated to any of the public traditional branches of the government. And in that regard, COFECE was characterized by being very vocal on competition issues regarding both public and private companies. In fact, it engaged in significant controversies with the federal executive in previous administration regarding various legislations and policy that thought to favor public companies as Pemex and CFE. And for that reason, it has like a different priorities from the government. So the former president, López Obrador, presented an initiative before concluding his mandate. And the idea was under the rationale of Republican austerity and organic simplification, and to give more coherence within the public policy, they proposed that the dissolution of various autonomous bodies and propose that their powers return to the secretariats or to the ministers that originally held them. So according to the initiative itself, the budget allocated to the agencies to be dissolved will be destinated to the pension funds and some social social contributions. So the idea is to simplify that with the public administration in order to have more budget for the social spending.
Okay, so I guess we'll get on to the implications of that, but a key issue seems to be budgetary reductions. So that's an interesting point to flag up at the beginning.
I was going to say, Matthew, for folks like you in the UK, this is kind of similar to that bonfire of the Quangos thing I thought that David Cameron had tried some years ago. So maybe Mexico is not unique in that sentiment anyway.
Right, the bonfire went nowhere, and I think they've tried it several times.
Well, yes, and of course it's the budgetary savings, but also the simplification of the decision-making policies, no, in order to have more coherence between the government view and this agency views.
So let me pick up a bit of that, Lucia. I mean, this is very interesting because as I understand it from you, the unique thing about the previous position of COFECE was that it had constitutional status.
Yeah.
And so as a result of that, in order to change the position, the government basically had to enact a constitutional amendment which resulted in where we are. Tell us a little bit, if you could, about sort of the key dates now that we understand the law has been passed, I think, as of November 28th or 29th. I think it's the 29th, I'm not sure. But now the thing has been passed. What are the next steps?
Yes. Well, as Matthew already stated, all the approvals from the Congress, from the local states, has been made. So on December 10th, the Constitutional Reform and Declaration made in the chambers of deputies and sent to the executive for its publications in the official gazette. So we are waiting for this publication that could be in any minute, tomorrow or any day. And then Congress must pass secondary legislation detailing the structure of the new entity, the powers and procedures, and maybe some updates to substantive competition rules. The bill, as approved, establishes a special transitory regime for COFECE and the IFT. So according to its provisions, the amendments related to these authorities will take effect 180 days after the enactment of the secondary legislation. But notably, the bill does not set a deadline for the Mexican Congress to pass this legislation. So this, it creates a little bit uncertainty on where exactly will be the transitory period for COFECE. But public statements suggest that the House of Representatives intends to start drafting the secondary legislation immediately. So we are expecting that the first half of 2025, we will have this secondary legislation, and the new authority will likely be operational by late 2025.
So it has to be enacted, and then after enactment, which I guess you're saying could happen at any time but is likely in play, then there's 180 days, at which point you have a new agency and I guess also a new law, correct?
I'm sorry, it's a little bit confusing. For COFECE and for IFT, it's a special rule that the 180 days starts passing when the secondary legislation is enacted. So the secondary legislation is not enacted yet, and it's being prepared. So there is no specific date or time or period for the secondary legislations to be ready. So we have like a impasse, and then when it is enacted, then we have the 180 days.
And in the meantime, I assume it's business as usual for COFECE until all of this stuff happens.
Exactly, business as usual, yes.
Understood.
Lucia, let's look at we've touched on this a bit already, and you've explained that there's a change from an autonomous constitutional body, moving it into the Ministry of Economics, into a new body. I know that the secondary legislation needs to come out as you've said, but can you just tell us what that broadly looks likely to mean in terms of the status of the new agency within the Ministry of Economics? And also, I've seen something which potentially seems important concerning a general judicial reform, which could potentially, it seems, also impact how the COFECE decisions are challenged, I guess.
Yes. Well, yes, the secondary legislations will be prepared and draft in the next months. But the constitutional reform states what will be the design of this new agency. The new agency will be a decentralized agency of the Ministry of Economy, not autonomous constitutional body like COFECE, but it says that it will have technical and operational independence, but ultimately report to the executive branch. No, and what is relevant here is that we know now that the constitutional preserves the independence of the body and its technical nature. But what will really be relevant for this independence be real, it's how it will be designed, who will appoint the president of the new body, and how it will operate. For example, in our former COFECO that was previous to COFECE, it was also a body that was within the Ministry of Economy, but it has a body of commissioners that were appointed for a fixed terms and with a stability under their place, so they can act independently. And we don't know exactly how will be the body that will govern this new agency. So that's relevant for the secondary legislation, and that's what we should be trying to review and to push in order to preserve the independence.
And Lucia, am I correct then in thinking that as part of this, the existing sort of group of commissioners, they would finish their term and an entirely new group of commissioners or leaders would be appointed when the new law comes in?
Yes, there will be. I mean, the commissioners that are now in place will end their mandate, and then we will have a new body that we are not know exactly how it will form and how the people that will form that body will be designated. That's part of the secondary legislation.
I understood, of course, that the Mexican government wanted this to apply to a broad range of tribunals and agencies.
Yeah.
But I also understand that COFECE seems to have ended up in a slightly different place than some of the other agencies. And I wonder if you can maybe explain to us sort of what that is and what happened to the other ones.
Yes, that's correct. That was a relevant modification amendment from the initial proposal. In the initial proposal, all those autonomous bodies will form part of the ministries of that has, I mean, the same kind of matters. But in the case of COFECE, it said specifically that it will be a decentralized body of the Ministry of Economy and will have independence. In the others, for example, we have the NIE, that is the transparency body, that will be a new unit of the Función Pública that now changed its name. That it's the agency that with the power to review all the administrative issues of the government. So it will be a unit of this new secretary, and it will not be as COFECE with a decentralized body with independence and technical autonomy.
So how did COFECE get the different treatment from other authorities like the Privacy Authority and such, which I understand were quite vocal about what they thought about this?
It was, I mean, the question was that we have some international, we have obligations in our treaties in which we have committed to preserve competition policy in a very, following the best international practices. And with that, we have, for example, the TEMEC, in which Mexico committed to have a technical body with guarantees of fair process and due process and a fair way to apply the law. So it was the idea that if we did not preserve this independence and this technical body, then we will be maybe in violation of our treaty obligations. So that's why COFECE has this different status from the others.
So I think you're referring there to the USMCA, the North American, the previous NAFTA agreement.
Yes, it's the USMCA, exactly.
Just going back to the status, one issue that, and you mentioned the commissioners would stop, but I mean, what about at the case officer and kind of general staffing level? I think one of the rationale for Mr. Lopez Obrador and then also taken on by Claudia Sheinbaum was that, you know, there's going to be a big reduction in the cost of all of this. So are they just going to reduce the staff dramatically?
Yes, of course, the commissioners will not be, they will stop, but of course the bill states that all the personnel from COFECE will pass to the new authority. But what is true is that there are budgetary concerns and the Congress is trying to cut budget. But of course, COFECE has a lot of procedures ongoing. It has very relevant powers, so I don't think that the state could cut a lot of the budget of COFECE in order, for the new authority, in order to save money. But of course, this is something that will be discussed in the following months.
So maybe like other jurisdictions, for example, the US and the UK, it's easy to say you want to cut the budget, but less easy when you actually look at how you're going to do that.
Just to pick up on that thought, Lucia, I guess that before COFECE was able to get that amendment, which kept them separate, I guess the idea was it was going to be combined with the telecommunications regulators. So I can understand the point where they're saying if you had initially tried to combine the two, there would be cost savings. But I think Matthew's question is right, that now you have two separate ones. It'll be interesting to see how they can make it more cost efficient if it's still a standalone agency.
Yes, that's true. The new authority will absorb the competition powers from the IFT, and there can be some savings. But of course, I don't think that it will be a dramatically easy to cut budget from this new authority.
And what about the judicial reform that was mentioned? Is that an important potential issue as well?
Yes, it's very relevant. Although, according to the Constitution, the specialized tribunals remain functioning for cases from competition and telecommunications. What is relevant is that some months ago, the judicial reform was also enacted, and this means that all the judges and ministers, the justice will be elected by the people. So in 2025, we will have elections from judges and all the judiciary, and half of the judiciary will be replaced with new judges that will be elected. So what will be the impact of that for competition is that, of course, it will be, the people is a little bit questioning if the specialization of the judges will remain. So that's the specific impact of that reform on competition.
One question I wanted to ask you, Lucia, was you quite sort of clearly explained how the secondary legislation will operate with respect to the creation of the agency. I guess the other question is, what would the secondary legislation do to the substantive Mexican competition law? Do you have any thoughts about what that new law, if there is going to be one, might look like?
Yes, that will certainly change. Today, we have a designating process that is in the Constitution, or that was in the Constitution, and in which there was like an open invitations to all candidates that want to participate in the process of selection. There are exams made by the universities. It is created an a selection committee that was formed by Banco de Mexico, by HICO, by the INEGI, other autonomous bodies, and it was and only the best candidate that has the best qualifications in terms of the exam could go to the second round, and from the second round there are only the best of the notes, no, of the ranks of each of the people. Then there is a list in which the president select one, and then that proposal goes to the Congress in order to have the new commissioner. So as you see, this was a designated process in which the executive, the legislative, and the academic and the technical people participated in order to guarantee technical competence of the commissioners. So that procedure disappeared in this new law. And then I think that if there is a body of commissioners, they will be selected directly by the president, or I mean, the designation procedure changed completely.
Right. So you could see a very different sort of group of people becoming heads or commissioners of the new agency.
Yeah.
If they change that process.
Well, they change it because it is not now in the Constitution. I don't think that they will incorporate that in the new legislation. Maybe they will have other kind of selection of designated procedure that will be not having these exams and this procedure in which technical capacities were guaranteed.
Lucia, you've explained that Mexico is to some extent limited by its international treaties, both on the structure and the actual competition law itself. And you were just discussing there how the commissioners will be appointed. I mean, it seems that the whole basis of this restructuring was to try to change how competition law is enforced in Mexico, regardless of its international obligations. So what do you see in the longer term as the practical implications? I mean, I've seen comments that it's going to mean that regulatory decisions will be more politicized, risk of cronyism, risk of favoring certain companies. How do you see that with a crystal ball playing out?
Well, I see an agency more aligned to the political agenda and the priorities of the government. Of course, this government wants to support the operations of some of the public entities, such as Pemex and CFE, that is the the Commission of the Federal Commission of Electricity. So I think that there will be less application of the competition law in some areas in which the state would like to have more decision on those matters. For example, energy and electricity, and of course more aligned with the political agenda of the government. Of course, most of the cases will still operating as technical and as relevant than today. No, but of course there will be some sectors in which I think that competition commission will not have some. It will be a little bit softer than in other aligning to the political agenda.
So maybe a bit of a bifurcation there. You can look at kind of, if you like, key sectors where industrial policy may play a wider or more important role, and other sectors which are maybe similar to the present.
Yes, exactly.
What about foreign companies active in or investing in Mexico, maybe just in the short term? And you mentioned that probably towards the end of 2025, the legislation may actually come into force, with a period during which the secondary legislation is going to be drafted and discussed. What should foreign companies be thinking about in the short term in terms of this legislation?
No, in the short terms, of course, I think that increased uncertainty for sure. Of course, especially regarding how the commission, this new authority will operate with respect to some sectors, as I said, and whether there will be any substantive change to the application of competition law in the other matters. This uncertainty, of course, doesn't help. But what is relevant is that that the relevant is that the competition policy will remain in Mexico in general. So I think that all companies should be operating, complying with the competition principles in general. No. Of course, as you said, potential for industrial policy considerations to play a larger role in merger reviews and investigation. That's something that could happen. And of course, I think that companies should closely monitor secondary legislation, no, and the early authority decisions to understand the new enforcement approach. But I expect to remain technical.
And I guess the sort of good news about that, although it does sound like the whole thing is deeply uncertain at the moment, but it does appear that because of the timing, businesses operating in Mexico, especially foreign ones, hopefully will not be taken by surprise because the 180-day plus the enactment timing that you've discussed.
Yes, exactly, and it will be. And we will have opportunity to present concerns to the Congress. Hopefully, they could attend.
Well, thank you, Lucia. That's been an extremely interesting discussion. We'd like to ask you some more personal questions at the end of our guests some more personal questions at the end of our episode. So firstly, could you please tell us something interesting or unusual about yourself that is outside your professional life that we wouldn't know if we only work with you?
Well, I mean, it's not unusual, but it's something that I like very much. I like a lot to be in the nature. I love hiking and cycling. So, and I like to take photographs in that kind of experiences. So that's my adventurous part that maybe not everybody knows.
And that's great. And we'll now move to the final section of our episode, which is the Curious Hat.
And now it's time for the Curious Hat.
And Lucia, as you and our listeners will know, we now ask you to choose a number, and we randomly select the question based on that number.
Okay, 28.
So I'm looking in the virtual hat for number 28. And 28 is, what book are you reading right now? And would you recommend it to our listeners?
Well, I am reading now I am reading a lot of books now. I am reading the last one of the name is Nexus, and it's a very interesting book on how this artificial intelligence will evolve in the future, and how the society will be handling these issues in the future. So yes, I recommend it a lot for the vacations and for the period of when you have time to read it, and it's very well written.
Is that a disconcerting novel, or is it a factual analysis?
It's like a futurist, but it's an analysis of the future. So it's a very nice book, and yes, I really recommend it.
Thank you, Lucia. That sounds like a great recommendation. Thank you very much for coming on again to this episode, and thank you everyone for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.